What's up, Crim Heist? Welcome to another Criminology educational video. And for today, we will be discussing Introduction to Criminology. By the way, my name is Sean Francis San Diego, also known as the Professor. So before we jump into our topic, please don't forget to like, comment, share, and subscribe to the Professor, and hit the notification bell for you to be updated for my next upload. So what to expect here in our video discussion? So we will be discussing criminal law and its characteristics, history of criminal or penal law in the Philippines, the different approaches in the explanation of crime, and the last one would be the schools of thought in criminology. So first in our discussion would be the history of penal or criminal law here in the Philippines. First would be the Code of Calantiao. This code was alleged pre-Spanish Philippine Penal Code, claimed to have been written in 1433 and discovered on the island of Panay in 1614. It consists of 18 orders for the proper punishment of certain moral and social transgressions. Depending on the gravity of the offense, punishment ranged from a light fine to being cut to pieces and thrown to crocodiles. The National Historical Commission declared the Code of Calantiao to be a hoax perpetrated in the early 20th century. So it is already declared by the National Historical Commission of the Philippines that the Code of Calantiao, which is the alleged pre-Spanish Penal Code or Philippine Penal Code, is just a hoax or gawa-gawa lang. Next would be the Code of Maragtas or the Maragtas Code. This code is proof of the advanced civilization of the Visayans because the Maragtas Code is used and originated from Visayas. Here are the rules of the code. First would be great penalty shall be imposed on laziness. Land shall be cultivated and planted. A lazy person shall be arrested and sold as a slave to work in the fields. When a slave becomes industrious and an able worker, the purchase money shall be returned to his purchaser and the slave shall be freed to till his own land. When a man after gaining his freedom again becomes lazy and improvident, he shall be rearrested and put into the deepest forest to keep him from associating with his own people. Theft and reaping plants grown and cultivated by others shall be severely punished, and the person found guilty shall have his fingers cut. Marriage to as many as 3 women may be permitted in the beginning in order to increase the population. Afterwards, only those who can support many wives and children may be permitted more than 1 wife. Poor persons shall not have more than 2 children. Children of the poor in excess of 2 in number shall be killed or thrown to Swift River. The authorities shall arrest a man who dishonors a woman, runs away and does not marry her. If the man is not found, the illegitimate child shall be killed and they shall be both buried in one grave. Parents shall no longer take of their children who beget illegitimate children. Next would be the theory of logomacy. This theory stated that we would handle or we would have no crime if we have no criminal law, and that we can eliminate crimes by merely abolishing criminal law. So ano lang yung gustong sabihin ni theory of logomacy? Only crime or nagkakaroon lang naman ng crime if there is a law punishing or prohibiting such act. So therefore, ang gustong sabihin ni theory of logomacy is get rid of the law, tanggalin ang batas or wag mag-implement ng batas para walang krimen. So to get rid of or to eliminate crime is to abolish criminal law. So why? 'Di ba isa sa mga sayings of nullum crimen nulla poena sine lege, which means if there is no crime, there is no law punishing the same or there is no law punishing the act. So therefore, kailangan may batas muna na nagpo-prohibit sa action na yon para ma-consider natin na yung action na yon is antisocial behavior and that antisocial behavior is a crime. Next would be crime, offense, felony, or misdemeanor. Let us first define what is crime. Crime is an act or omission in violation of a criminal law in its legal point of view. An antisocial act, an act that is injurious, detrimental, or harmful to the norms of society, they are the unacceptable acts in its social definition. So para hindi tayo maguluhan, crime is the generic term or the general term or the mother term. So, violation siya ng criminal law. And criminal law is consists of different laws. Nandiyan si Revised Penal Code, nandiyan si Special Laws, and nandiyan yung mga jurisprudence from the Philippines and Spanish cases. Next would be offense. When we say offense, it is an act or omission that is punishable by special laws. So, ibig sabihin, isang part lang ng criminal law yung vina-violate sa offense. Or, pag violate mo yung isang part ng criminal law, which is special law, that is considered or that can be categorized as an offense. So, what is special law? It is a statute enacted by the Congress, penal in character, which is not an amendment to the revised penal code. The following are an example of special law: Republic Act, Presidential Decrees, Executive Orders, Memorandum Circulars, Ordinances, and Rules and Regulations. So for easy understanding, special law, these are new laws enacted by the Congress which is outside the revised penal code. But it is the same with revised penal code which is penal in character. So ito yung mga examples niyan. So if you see a law which starts with the Republic Act, Presidential Decrees, Executive Orders, Memorandum Circulars, Ordinances, Rules and Regulations, these are considered special laws. Next would be felony. When we say felony, it is an act or omission that is punishable by the revised penal code, the criminal law in the Philippines. So, pag sinabi nating felony, ito yung violation of revised penal code. Kasi ang offense is violation of special laws or special penal law. Next would be delinquency or misdemeanor. When we say delinquency or misdemeanor, these are acts that are in violations of simple rules and regulations, usually referring to acts committed by minor offenders. So, usually these are just infractions or violations of simple rules and regulations, and the perpetrator or the offender is a minor. Next would be law. Law is the rule of conduct just and made obligatory by the legitimate authority for the common observance and benefit. It is symbolically represented by a blindfolded woman carrying with one hand a sword and the other a balance. In the study of criminology of all the branches of law, criminal law is the branch that is closely touched and associated. So for easy understanding, law, these are rules and regulations enacted, formulated and being implemented by our government for the purpose of maintenance of peace and order and protection of lives and properties. So, in the study of criminology, ang pinag-aaralan natin na branch ng law is criminal law. So, what is criminal law? Criminal law is the branch of public law which defines crime, treats of their nature, and provides for their punishment. Criminal law is only one of the devices used by the government by which its purpose are to organize the society, protection of the citizenry, and ensuring the harmonious way of living in the community. In the Philippine settings, the Philippine criminal law is comprised of two books which consist of the crimes, natures, and punishment. So, ano yung mga books na yon? So, the first book would be Revised Penal Code Book 1, which is composed of Articles 1 to 113. So, Title 1, Felonies and Circumstances which affects the criminal liability. Title 2, Persons criminally liable for felonies. Title 3, Penalties. Title 4, Extinction of criminal liability. And Title 5, Civil liability. For Revised Penal Code Book 2, which is composed of Articles 114 to 367, Title 1 would be Crimes Against National Security. Title 2, Crimes Against the Fundamental Laws of the State. Title 3, Crimes Against Public Order. Title 4, Crimes Against Public Interest. Title 5, Crimes Relative to Opium and Prohibited Drugs. Title 6, Crimes Against Public Morals. Title 7, Crimes Committed by Public Officers. Title 8, Crimes Against Persons. Title 9, Crimes Against Personal Liberty and Security. Title 10, Crimes Against Property. Title 11, Crimes Against Chastity. Title 12, Crimes Against Civil Status of Persons. Title 13, Crimes Against Honor. Title 14, Quasi-Offenses. And Title 15 is Final Provisions. So what are the sources of criminal law, or ano yung nagko-compose sa criminal law? So, first is Act 3815, known as the Revised Penal Code, which yun yung minention ko kanina, yung title or yung Book 1 and Book 2. Second is special penal laws. Ito yung diniscuss ko kanina, which is these are new laws that are penal in character and amendments of the revised penal code. Presidential decrees, which is a part of special penal law. Executive order also. Of course, the Spanish penal code. Jurisprudence from the Supreme Court of the Philippines and Spain. Next would be history of Philippine criminal law. When the Spaniards invaded the Philippines, they enforced the Spanish Código Penal and extended to the Philippines by Royal Decree of 1870. It took effect in the Philippines on July 14, 1876. The said law was effective up until the American invasion or the American colonization. It was amended under Act No. 3815 on December 8, 1930 and took effect on January 1, 1932 and was called as the Revised Penal Code of the Philippines. So imagine, the Revised Penal Code of the Philippines is almost 90 years. Next would be characteristics of Philippine criminal law. So first would be the principle of generality. So in the principle of generality, criminal law is binding on all persons who live or sojourn in the Philippine territory. So for easy understanding, yung principle of generality is that lahat ng tao na nasa Pilipinas, mapa ikaw ay citizen, mapa ikaw ay nakatira doon, or you are just a transient or yung mga dayuhan or yung mga bumibisita lang or mga nagbabakasyon, you are under the power or you are still liable if you violate criminal law or if you violate the Philippine criminal law. So what are the exceptions? First is if you are a head of the state or of other countries, such as you are the president or the chief executive, head ministers. Next is foreign diplomats. Next is ambassadors who are duly accredited to a country. Next is foreign troops permitted to enlarge within a territory. So, criminal law undertakes to punish crimes committed within Philippine territory. That is the principle of territoriality. So, lahat daw ng ginawang krimen inside the Philippine territory, ikaw daw ay liable doon. So, the territory is divided into two. Terrestrial, which are doon sa land, jurisdiction exercise over land, and fluvial, ito naman yung sa maritime and interior waters. But there are exceptions. It can still be applied under the following conditions kahit wala ka na sa Philippine territory. If you committed an offense inside a Philippine ship or airship, ito yung mga barko or mga eroplano na nakarehistro sa Pilipinas. Next is if you forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. So, pag daw ikaw ay gumawa ng pekeng pera or nag-distribute ka ng pekeng pera outside the Philippine territory, you are still liable. Next is all being public officers or employee should commit an offense in the exercise of their functions. So for if you are a government employee or a government public officer and you committed a felony or you committed a crime or an offense in connection to their official function or duty as a public officer or employee. The last one would be should commit any of the crimes against national security and the laws of the nation defined in Title 1 of Book 2 of this code. Next would be principle of prospectivity. Criminal laws cannot make an act punishable in a manner in which it was not punishable when committed. What is the exemption to the rule? When a new statute dealing with the crime established conditions more lenient or favorable to the accused, it can be given a retroactive effect. So, bigyan natin siya ng madaling example. For example, ang ginawa mong krimen or ginawa mong crime is robbery. And ngayon, for example, ang violation or ang punishment in violating criminal law or in or pag ikaw ay gumawa ng robbery is, kunyari is, lifetime imprisonment or life imprisonment. So, ginawa mo yung robbery noong September 24. Come September 26, 2 days after, nagpasa ang batas na ang magiging penalty for the crime of robbery is death penalty. So, will the new law took effect doon sa ginawa mo or ang magiging punishment mo ba is death penalty or life imprisonment? The answer would be life imprisonment only. Kasi magiging irretrospectivity lang siya or magtutok effect lang siya or magkakaroon lang siya ng retroactive effect if it is favorable or lenient to you. So, a good example is, gumawa ka ng robbery ng September 24 and yung penalty doon is death penalty, kunyari. And then come September 26, penalitan or inamend ang batas at ginawa na lang itong lifetime imprisonment. What will be your penalty? Life imprisonment or death penalty? Of course, magtutok effect yung bagong batas because it is more lenient or favorable to you. Mas lenient or favorable naman yung lifetime imprisonment kesa sa death penalty. So what is the exemption to the exemption? Which is, when we say exemption to the exception, hindi ka mabibigyan ng retroactive effect even if it is more lenient or favorable sa'yo. If you are a habitual delinquent. What is habitual delinquent? It is a person who within the period of 10 years from the date of his last release or last conviction committed the crimes of this. So for example, in the past 10 years, gumawa ka ng falsification and robbery. So, ikaw ay mako-consider na habitual delinquent. So, magiging habitual delinquent ka lang if ito yung mga ginawa mong krimen. Falsification, robbery, estafa, theft, serious or less serious physical injury. So, ito yung tinatawag natin na threat cell. Next is the approaches or the primary approaches in the explanation of crime. So, nandiyan si objective approach. When we say objective approach, criminal behavior is explained in terms of factors extraneous or irrelevant to the offender which are sociological, cultural, and economic. So, para mas mapadali, si objective approach, these are external factors. When we say subjective approach, criminal behavior is explained in terms of factors within criminal. Example is physical, biological, and mental traits. So, itong si subjective approach, it is internal factors. Unlike yung objective approach, it is more on external factors. Next is the different approaches in the explanation of crime. First would be biological approach. It explains that human beings commit crime because of internal factors over which they have little or not control. So, ibig sabihin, this is a type of subjective approach. Anong good example dito? Chemical and mineral influences, diet and crime, and hormonal influences. So, kunin natin si hormonal influences. Pansinin niyo yung mga babae, pagka meron sila monthly period, mataas ang hormones nila, therefore, mainitin ang ulo, they are too emotional. And if a person is too emotional, they have criminal tendencies or they are vulnerable in committing crime. So, yun yung good example ng hormonal influences as with respect to biological approach. Next would be causal approach. This is a study of the causal link that exists between the defendant's action and the plaintiff's injury. It is the observation of facts in relation to phenomenon of crime, interpreting them in relation to the possible causes of criminal behavior. A cause may be necessary or sufficient. Ang sinasabi lang dito is that if result B invariably follows cause A without any other factors being required and cause A cannot be replaced by any other alternative, then cause A is both sufficient and necessary cause. Next would be deficient in probity approach. Ang sinasabi lang dito is that criminals have deficient in probity according to Dr. Maurice Parmelli, which ang ginagawa nila usually is crimes against property. So what is probity? It is the quality of having strong moral principles, honesty, and decency. So ibig sabihin yung mga criminals daw ay may deficient or mababang probity or mababa yung kanilang quality of having strong or right moral principles. They are not honest and they are not decent, according to Dr. Maurice Parmelli. Next would be descriptive approach. It describes the phenomenon of crime and those who commit it. It covers all aspects such as personal traits of criminal and the various forms of criminal behavior. Next is organically inferior human traits approach. This study was carried by Evert Houghton and William H. Sheldon. Houghton stated that criminals are organically inferior. So, yung human traits daw nila ay organically or naturally inferior unlike the normal people. Houghton had studied 13,873 male criminals and 3,023 persons of control group, the study was conducted in various American states. To Hutan, the criminal is an inadequately developed runty fellow, while to Sheldon, the criminal is husky and athletic type fellow. Next is economic approach. So this is a type of objective approach wherein it studies external economic factors. Ito yung economic situation na meron yung criminal na nag-push or naging motibo niya or naging cause niya or turning point niya para gawin yung krimen. Next is endemic approach. What is endemic? It is a condition regularly found among particular people or in a certain area. It studies those factors that arise from local conditions or belong to a particular period of the year or the specified area that make a man criminal. So usually ginagamit to sa mga crime-prone areas. Kaya 'di ba pagka ikaw ay nakatira or pinalaki or lumaki sa crime-prone area, you have criminal tendencies or you are vulnerable in committing crime. So, yun yung endemic approach. Next is environmental approach. It seeks to explain the phenomenon of criminal behavior with reference to factors outside the personality of the delinquent. So, this is also an objective approach wherein it tries to explain through environmental factors kung bakit nagkakaroon or nade-develop ang criminal behavior ng isang tao. Next is functional psychosis approach. As we all know, psychosis has two different types. Meron niyang organic origin and meron tayong non-psychosis origin or functional psychosis. For organic disorders, ito yung alam natin kung bakit meron siya psychosis. It is because of the structural defects or physiologic dysfunction sa kanyang utak. When we say functional disorders or functional psychosis, ito yung hindi natin alam kung bakit siya nagkaroon ng psychosis. So, for organic psychosis approach, patients of this abnormality commits offense with astonishing openness and silliness. For traumatic psychosis, they usually commit crimes of violence. For encephalitis lethargic, they usually commit crimes of explosive and sexual in nature. For senile dementia, they usually commit varying crimes or various crimes. And for epilepsy, they usually commit crimes of sudden violence. And for schizophrenia, these are patients of this abnormality suffer split-mindedness. Next would be heredity and criminal families approach. So, dito naman, sinasabi natin is subjective approach naman to, internal factor. Kasi, kumbaga nasa dugo or nasa genes daw natin yung criminal behavior. So, there are two studies na sumikat dito in criminology to support this claim. Studies were conducted by Dugdale in the United States of America on the Jukes, or ito yung mother of all criminals, si Ada Jukes in 1877. And kay Henry Herbert Goddard studied on the Kallikaks, wherein si Martin Kallikak nagkaroon siya ng dalawang asawa. Yung isa niyang asawa is maayos, and yung pangalawa niyang asawa is pariwara yung buhay or may mga criminal tendencies. And lahat ng naging anak niya doon sa maayos niyang asawa is naging professionals, naging maayos ang buhay. While yung mga naging anak niya doon sa pariwara or sa may criminal tendencies, naging criminal sila lahat. So, it means genes talaga or nasa blood daw nakaka-apekto yung pag-development ng criminal behavior ng isang tao. Next would be individualistic approach. It focuses its attention on the biological, mental, and other characteristics of the offender to explain the cause of his delinquent behavior. Next would be physiological approach. It is an approach to criminology made by endocrinologists who found that glandular malfunctioning caused by delinquent behavior. So, itong physiological approach, ito daw yung merong abnormalities in the endocrine gland, wherein ito yung nagsisikret ng mga hormones natin. So, again, katulad din sa biological approach, pag mas mataas ang ating hormone counts, nagiging too emotional tayo, and that can affect our behavior, and maaari tayo magkaroon ng criminal tendencies. Next is social approach. Man may live in isolation, but generally, he lives in society. So, these are sociological factors that may affect the development of criminal behavior. And this is an example of objective approach. The last one would be therapeutic approach. This approach is recent of origin, so it considers the criminal as a victim of circumstances and a product of various factors within the criminal and the society. The last one would be twin research approach, violent due to environmental influences as prejudices of honor, politics, and religion approach. Now let's go to the last topic, which is the schools of thought in criminology. So we will be discussing three schools of thought, namely classical school, neoclassical school, and positivist school. For classical school of criminology, the classical school developed during the Enlightenment. So ang naging salient features nitong classical school of criminology is tinanggal niya yung excessive and cruel punishment to criminals. Because Cesar Beccaria, who is the father of classical criminology, argued for more humanitarian forms of punishment. Sinabi niya dito that punishment should fit the crime and not be excessive. The primary premise or feature of this classical school was the equality of all people. Sinasabi rito that every person should be treated equally under the law. Ito yung sinasabi natin sa mata ng batas, lahat ay pantay-pantay, regardless of your status in life. Criminal behavior would be subject to similar punishment, and people had to know what categories of conditions that are punishable. So, central to the classical school was the presence of the free will. So, ang sinasabi kasi sa concept of free will is that people act within reason. So, mayroon tayong kalayaan mamili. And therefore, pag ginawa daw natin yung action na yon, it is presumed na ginawa natin yon, bago natin ginawa yon, nasa tamang pag-iisip tayo para isipin yung mga magiging resulta ng actions natin. So, therefore, sa concept of free will is that your actions, accountable ka dapat doon sa mga actions or mga moves na gagawin mo. So, crimes are chosen through free will. They should be punished swiftly and proportionally to the crime. This is the most effective deterrent to crime according to the classical school of criminology. Next would be the neoclassical school of criminology. Just to give you a heads up, the neoclassical school of criminology, they adapted the concept of classical school. It's just that they mandated or amended some of its features or may mga binago sila. So, ano yung mga binago nila? Allowing mitigating circumstances by looking at the situation, both physical and social environment in which the individual had been placed. Kasi sa classical school, it is more of an subjective approach wherein it is only internal factor, yung free will ng tao. Unlike dito ngayon sa neoclassical school, hinaluan na nila ng objective approach which is external factors. Ano yon? Yung social environment. Some allowance was given for an offender's past record. So, sinasabi rito is tinitrace nila yung mga offender's past criminal record and that may affect the decision about someone's sentence. Consideration also are given for factors like incompetence, pathology, insanity, impulsive behavior, and binibigyan nila ng leniency yung may mga mentally ill or yung mga mentally incapable. The last one would be the positivist school of criminology. For positivist school of criminology, it opposed the classical school's understanding of crime. Sinasabi kasi dito, all people are different. So, lahat tayo may different concept or understanding ng right and wrong. This needed to be a barometer for punishment. The person and not the crime should be punished. So, Enrico Ferri adopted the inductive method and set out to create a science that would explain the causes of crime within society and the individual offender. The school started by considering a crime a product of heredity and environment. So, ano na naman to? Heredity, it is a subjective approach, and environment, which is objective approach. Instead na nakapokus tayo sa conduct ng kriminal, they focuses on the behavior of the criminal. Environmental factors such as societal conditions and pressures interacts with hereditary factors that may pushes the person to commit crime. The deterministic school was more concerned with the actual or would-be criminal rather than criminal conduct. So ito, nakafocus siya sa prevention of crime. Positivism's focus on the individual may have been the greatest contribution to criminology and the criminal justice system. So the positive school led to classifications of offenders such as habitual criminals, which I discussed kanina, as well as categories between insanity and sanity, and also led to the use of psychology in studying offenders, opening the way for different kinds of sentences and treatments that fit the criminal and not the crime. Kasi sa classical school, ang inaano kasi dito is kung ano yung kriminal na ginawa, dapat proportionate dun sa punishment. Dito kasi sa positivist school, kailangan yung punishment is proportionate doon sa situation ng kriminal. So thank you very much. I do hope that you learned a lot from today's video discussion. Please don't forget to like, comment, share, and subscribe to the professor, and hit the notification bell for you to be updated for my next upload. So see you on my next educational video. Thank you!